All right, I think I got it. So, Ann, are we good on the recording now?
You are.
Okay. Thank you everyone for being here. My apologies on me being the speaker and not Doug Hausman. So we can only do what we can. I'm going to be going over various topics today that concern protecting elders' wishes near the end of life and hospice circumstances. I know that in our practice area, we deal with this regularly. And so while a lot of this is or can be routine, it's always good to have a refresher and see and or hear about some other viewpoints. So, step one, if we have an elderly client or someone comes in the door and we have an issue as to what the elder wants to do, step one is how do we determine what the elder's wishes are? And so in regards to capacity, we assume a lot of times by statutory presumption that a person has capacity to make their own decisions because that's what statute says. We don't have to try to prove that they don't if we don't have any reason to doubt that they appear to have clear and lucid interactions with us. The most important thing is, are they able to articulate what their wishes are? And if they are, then that's step one. In regards to step two, the analysis as to if there are questions of capacity, that does not have a clear bright line rule. Unfortunately, there is no test that we can just give a person and say, you scored a 10 out of 20 or a 15 out of 30, therefore you fail. You do not have capacity to make these decisions. There are capacity declarations that are used in conservatorship cases, and those are completed by treating physicians or treating, I believe, psychologists. So in a situation where there were questions as to capacity, that could be completed and relied upon. An MMSE, mini mental state exam, or MOCA exam, those differentiating exams are like litmus tests for capacity to provide helpful information as a baseline as to whether the person has certain deficits and what those deficits may be in regards to cognitive function, executive function, and other areas. The other one is perhaps a doctor's letter. If you have a letter from a doctor stating that the patient who is your client has memory issues or has been deemed, quote unquote, unable to make their own healthcare decisions, then that could also be something that would be taken into consideration when someone walks in your door stating that they have the desire to do something or they have certain wishes that they would like honored. So these are all things that can be helpful, but ultimately for those of us in this practice area, we know that all of those things, unless certain elements are met, are not conclusive. So probate code 810 to 813 deal with legal mental capacity and the standards. I'm not going to bore you with reciting what you probably are all very well familiar with, but I think that it is important to read the highlighted or bold words that we're going to be dealing with for the purposes of today's presentation. What are we going to do if an elder has memory problems, cognitive issues, or mental illness? Does that mean that they're not able to make decisions? Well, the answer is it depends. And so for this analysis, we go to 810, which is the number one place that we should go to. We talked about the presumption, that's subdivision A. In regards to subdivision B, this deals with making medical decisions, and that's essentially something that will be necessary in regards to anything concerning end of life decisions, and the other part performing other actions. So we can get into plans towards the end of life when a person suffers from a certain condition, how they want to be treated, and even now assisted suicide, which is legal in many states, including California, under certain circumstances. So all of those things are important in regards to an analysis of what the elder's actual wishes are. And then going to subdivision C, this is imperative if there is a situation where a practitioner believes or an individual believes another person is unable to make a decision. Generally speaking, unless the estate planning instrument states otherwise, you will need a judicial determination. And it provides the examples, but for purposes of this presentation, you would want to know whether that person suffers from one or more mental deficits that are so substantial that under the circumstances that person should be deemed to lack the legal capacity to perform a specific act. And that has to be based on evidence of a deficit in one or more of the person's mental functions rather than on a diagnosis. So while that is a mouthful, what that essentially means is just because a person has been diagnosed with dementia, that does not mean they need to be in a conservatorship, does not mean that they are unable to make any decisions, doesn't mean that they can't do estate planning. It doesn't mean a whole lot in and of itself, but it also doesn't mean nothing. It just means that further analysis needs to be done in regards to the specific deficit that dementia would potentially lead that person to have, and a specific act. So under probate code section 811, this just spells out a little more clear that, again, in the highlighted part, that for purposes of this presentation, that if a person lacks the capacity to make a decision or do a certain act. So that has to be supported by evidence, and what we were just talking about earlier of a deficit in at least one of the following mental functions. And there's a long laundry list under probate code section 811. I like to think of Tom Brady, not for the reasons that Doug Hausman likes to think about Tom Brady, but I like to think of Tom Brady in this regard because he is an older quarterback. A lot of people say he is too old to play football. They say that he can't run anymore. His knee is injured, but he won a Super Bowl last year. So in regards to incapacity, the question should be, is this person able to do the act in question? So Tom Brady is a quarterback. He has to stand and throw a football. He may not be able to sprint and run, but if all he needs to do is the specific act of throwing a football, then that is something that he can do and therefore has capacity to do that act, even if he has certain impairments. And then another example that I like to use are high school basketball players. They can be athletic, young, seem like they can pretty much do it all, but they may not be able to jump high enough to dunk a basketball. So they have the capacity in general to play basketball, but the specific act or the certain act in question, they're incapable of doing, which is to dunk a basketball. So again, just because a person has, certain types of symptoms, or you look at a person and you say, this is an elder, this person is older, it doesn't mean that they are unable to do something. Even if the person is now slower than they used to be, which we can hear all the time, or they're noticeably impaired, it does not necessarily mean that they cannot do the act in question. So it's a situation that unfortunately doesn't have a bright line rule. I mean, you can have a person that may get their memory refreshed, may have good and bad days, may have lucid moments. So These are all things to think about. And the standard, again, is pretty low. Think of just an 18-year-old in general. You may not necessarily like their choices and the decisions that they make, but it's not what you like, and it's not even what's necessarily something that is normal to them. It is whether they have the capacity to make that decision. The other part of this analysis has to deal with undue influence and pressures by others. If an elder who is wanting to talk or make decisions about end of life or hospice care is being steered in a certain direction that they cannot resist or are unable to otherwise state what they want to do without the other person, that's where we get into this arena of undue influence. And we have seen these types of cases where a person may say, you know what, I don't feel like I can do this. I need somebody in the room to tell me what to do, and then I'll do whatever they say, versus I want their input and then I'll make a decision. So, how do we know that a person is being unduly influenced? This is one of the toughest things that we deal with as practitioners. It's very difficult to properly diagnose this at times, but all we can go off of are indicators. And for purposes of our analysis with end of life decisions concerning care and hospice, some of them would be a drastic or sudden change late in life in regards to what their wishes were. For example, if a person always wanted to live in their home and then all of a sudden towards the end they say something like, you know what, I don't want to live in my home, I'm fine with you putting me in a facility, that could be a red flag, because most people tend not to want to go to facilities. That would require further analysis. Maybe there's a really good reason. For example, that person is a social person and their spouse just passed away, or their kids are no longer in the area and they want to have social interaction, then that would be a very commonsensical move to make. Another indicator of undue influence could be cutting off long-term family members in favor of a stranger. If you have a scenario where family have been involved, children have been involved, a spouse has been involved, and then all of a sudden that person's cut off, or a person who has just ingratiated themselves or has just arrived on the scene, that would be something that would be suspicious and that would require further investigation. And then another one is siege mentality, an idea that the person, the elder, is not making a decision that they necessarily would make under any circumstance where there aren't other pressures, and then now they start to feel like the people around them are out to get them. My kids, I can't believe what they're trying to do. They're trying to take my rights from me. They're trying to conserve me. They're trying to put me in a home, things like that, where the elder may not remember that, in fact, that person was just doing what the elder told him to do. The elder told him maybe a week ago, a year ago, 10 years ago, if and when this happens, please do this. So, there can be issues with siege mentality, the world's against me, my family's against me, and those types of instances. Let's see. So in regards to incapacity, the best thing that we could go off of, if a person, has diminished capacity or is looking like they are no longer with the sufficient capacity to make decisions, is do they have documents that outline what they want? The number one thing is an advanced healthcare directive, and whether that allows for immediate decision making or it requires an incapacity standard to be met. So if it requires an incapacity standard to be met, then what is that standard? And California law does authorize individuals to put in their estate planning documents when certain capacity thresholds are triggered or actions to be taken by their agent. So It does not require going to court necessarily to trigger that function. So if you have a situation where a doctor's letter is stated in an advanced healthcare directive to trigger an agent to begin to act, then that would be sufficient. Same thing with the power of attorney for healthcare. That's slightly different than an advanced healthcare directive in that the agent under a power of attorney for healthcare could have even more broad powers than what is generally in an advanced healthcare directive to make immediate healthcare decisions and to do things even without necessarily the consent of the principal. So sometimes a power of attorney for healthcare allows for an agent to essentially do what they feel is best. The other thing that would be important to go off of in determining what an elder's wishes are would be written instructions and or recordings. Sometimes a person will record in front of their family members or by video chat or whatever what their wishes are. That would be helpful in the event of any type of conflict or where a person is not sure what needs to be done for whatever reason. Last but not least are what are known as physician orders for life-sustaining treatment or a POST. There's a website provided on the slide. If you go to that link, you'll see that there are now downloadable forms that are in over 10 different languages. This is helpful for people who have unfortunately gotten to a point where they may not be able to have a person come in and witness an advanced healthcare directive or a power of attorney, but they need to have some immediate decisions made and have those made by an agent, and that's something that can be completed. And then again, even with these items, if there's a dispute as to what the elder wants towards the end of their life or how they want to be treated, then oftentimes you get into a situation with battling or competing individuals who want to honor wishes based on what they've heard or what they're aware of. And that can be family members or even doctors. Sometimes doctors are under a belief that a patient wants one thing, the patient tells another doctor something else, and that can change things. So, sometimes the courts need to get involved. And I know that for a lot of us, we all remember the Terry Schiavo case with end-of-life decisions when there was no healthcare directive or document stating what her wishes were in an unlikely event, such as the one that she was suffering from. Conservatorship, this is the most drastic action that can be taken when a person is essentially unable to fend for themselves and the person requires court supervision and protection. But this is something that oftentimes is necessary under certain circumstances. The standard is heightened. It's a clear and convincing evidence standard. So it's not something that should just be done when a person has questionable decision making. It should be done when protection and court supervision are needed, and it's imperative that the person have that to avoid harm. This is a situation where if a person is in their end of life stages or wants to take certain types of pain medications and or is dealing with certain pressures concerning where to live, how to go about living, whether to even be on hospice, that this is something where the court being involved to preserve what the person's wishes are or determine what would be in the person's best interest would be appropriate, such as when a person has questionable capacity or when the person is hearing things from all different angles, and then depending on who's left with that person last, that the individual goes off of what that advice is. For example, if we have an individual who is with cancer and has 6 months left to live, but may have some cognitive issues, and they're with their children and their children say, hey, just stay home. And then they're with their brother or sister and they say, hey, you should be in a social environment. And then depending on who they're with, they change their mind. Oftentimes getting a conservatorship, having the court involved, having an assessment done by a professional to determine what their ability is to actually make a decision is important. And then in regards to this scenario, I like to think of Britney Spears because of a situation where initially it seemed like she did need some court protection, but it is one of those things where she now is expressing her wishes and the court has to make a determination as to what is in her best interest. In regards to end of life and hospice, generally a person is placed on hospice when they've been diagnosed with a terminal condition and they have 6 months or less to live. You can have scenarios where people live much longer. They essentially have blocks of 6 months where they are re-examined to determine whether hospice is appropriate. For us in Contra Costa County, Hospice of the East Bay is what we are familiar with and a great resource. They provide supportive palliative care and the Bruns House as well for people who require immediate care in the form of inpatient care and have acute symptoms. So instead of just having a person who otherwise would need nurses or be in more of a heightened environment than their own home, they would be, instead of going to a hospital or a skilled nursing facility, they could go to the Bruns House towards the end of their life. And there's a link to also take a look at in the event that you have clients or individuals who you work with who are interested in those options. Palliative care is a word that we use. It means specialized medical care for people who have essentially these types of serious illnesses that are terminal in nature, and that includes cancer or heart failure. Palliative care is designed to provide quality of life for the person. It's not necessarily designed to cure a person. So it's a situation where it's understood that you have a person who may need a certain type of, for lack of a better term, hand holding or additional social interaction, and that's an integral part. So just because a person's growing older or a person's terminal doesn't mean they don't have any options. They do have these options, including hospice and palliative care options. Now this leads to why I have a job, how to protect the elder's wishes. Oftentimes we get into a situation where bad communication, stubbornness, pride, all of those human elements lead to disputes, but a lot of that can be avoided early on if the elder has capacity and is willing to have a family meeting to communicate with the people who would be the ones affected by any of these wishes or decisions affecting the elder, such as assisted suicide or moving from a home to an assisted living facility or having an in-home caregiver. These are things that for people like myself, I don't pay a lot of attention to on a day-to-day basis because it doesn't affect me personally. But as a practitioner, when I see my clients come in and see people who are affected by this, it is tremendously important that the people who are facing these types of scenarios have these tough discussions, have these family meetings, have these tough talks, because if they don't, then it can snowball. And then when these talks are had, if there's a lawyer for that elder, that is often advisable so that the elder feels a sense of protection and independence in the decision-making process, and the lawyer can advocate as well, letting the family members know this is what the elder wants to do. It may offend you, it may not be what you want, but this is what the elder wants to do. Have that documented. That can go a long way. Naturally, the second part is having estate planning in place, as we talked about, which documents the elder's wishes. And then obviously, if everything else fails, seeking court protection and involvement. If you have an elder who has capacity and you're dealing with a situation where someone is trying to force the elder to do something that they don't want to do, or pressure the elder, or create some type of an environment that is not suitable for the elder, which is hostile or harassing, then there can be ways to deal with that. Unfortunately, that usually involves court action. And if you have a power of attorney and the agent under the power of attorney or the healthcare directive is not acting as the directive or the power of attorney states, then certain family members can take legal action under California law, even if they're not named as agents. So it's not a situation where a sibling who's not named under a power of attorney of a parent just has to sit by and watch another sibling essentially run roughshod on, what the elder's wishes are. If the elder says, this is what I want to have visitation, I want to go travel, I want to do these things towards the end of my life, or I want to have certain types of care provided, and that's not done, then a family member doesn't just have to sit back and say, what am I going to do? Obviously, conservatorship, which is what we talked about, is available, and that involves the court. The court-appointed attorney is involved to protect the elder and advocate for the elder. It also involves the appointment of a court investigator, which is very helpful because the court investigator can interview people, look into things, and provide a report to the court in regards to what the observations are of a non-party witness. An EATRO, or elder abuse temporary restraining order, may be necessary if you have a scenario where an elder's wishes are not being honored and you need to get injunctive relief or protection to allow that elder's wishes to be honored. And then finally, potential civil action for elder abuse if there is a circumstance where the treatment results in actual physical harm or mental suffering, or the deprivation by someone who is a caregiver or in charge of the elder, and the elder is not able to obtain goods and services, or services that are necessary to avoid such physical harm or mental suffering. So in a nutshell, there are a lot of options involved in protecting an elder's wishes while the elder has capacity. And this is not a fully comprehensive list, but hopefully substantially helpful in providing assistance to those who are looking to protect an elder. And then in a situation where an elder no longer has capacity, or as we were talking about, has questionable capacity, then this analysis is not too different from the other analysis. Again, if the elder has questionable capacity, a family meeting is always helpful in a delicate manner to try to talk through issues and see if a middle ground can be reached. Obviously, having a lawyer present would be important. That would be up to the lawyer to determine whether or not the client still had contractual capacity to continue on with the relationship or not. Again, just because a person has some memory issues or has trouble remembering certain events or things doesn't render them incapable of doing certain specific acts, such as hiring a lawyer to protect that person. In regards to the no longer having capacity, a family meeting in that situation, would have to be extremely delicate with the elder, especially when people have taken that type of position, because oftentimes individuals will say, my mom, she can't make any decisions. And then at an interaction or meeting say, hey, mom, don't you want to do this? So, those are things where people have to be careful, because you can't have it both ways. You can't have capacity and totally lack the ability to make decisions at the same time. So these are things that are important for people to know about. and implement in their practice. And then it comes back to philosophy and also what is theory and what is reality. I mean, end of life decision making is very, very personal and is something that should be greatly respected and given a high degree of deference to. Unless a person knows what they are doing and is really informed of what they're doing, they shouldn't just be making decisions. And the reality is that in regards to decision making, people change over time. So you can have a person who for 20 or 30 years wanted to have one person in charge, but family circumstances have changed, dynamics have changed, views have changed, beliefs have changed, and then they don't want that same person in charge. And so those wishes should be respected unless there really are clear factors that show this person is no longer capable of making these decisions or is actually a victim of some type of pressure on undue influence. And the other factors that I outlined are, things that change over time, including responsibilities. Sometimes when a person is single, they think about things one way. When they're married, they think about things another way. They get divorced, they think about things yet a different way. When they have children versus no children. And then even when their children have spouses or their children don't have spouses. All of those things can affect how a person deals with end-of-life decision-making and the choices they make. And then again, talking about assisted suicide, life support, DNRs, the law changes over time. So when advising a client about what their end-of-life wishes are, a client may not have been even aware that they have assisted suicide as an option. You may have a client who didn't even know what life support means. You may have a client who doesn't fully comprehend what a DNR is. So just throwing these terms out isn't fair to a client if a client is not fully aware and hasn't done their homework in regards to what this means, especially in California. Assisted suicide is not as easy as picking up the phone and telling a person, come down, give me some pills. So these, again, are very difficult, very personal decisions. And these are things that before a person, especially an elder who's on hospice, end of life, is making, they should be properly advised and instructed about. And then a slide here, the last one, some suggestions from California's Attorney General in regards to end-of-life decision-making and preparing for that process. It provides helpful step-by-step in regards to getting information and having wishes documented using an advanced healthcare directive or other power of attorney for healthcare. And then it also goes into considering palliative care, pain management, and hospice care as part of the estate plan. So I think it's very important for people to have those talks. I know it's very difficult, like I said, especially when someone is quote unquote younger, in their 40s or 30s, and maybe some people in their 50s to even think about those types of things because they say, hey, look, I've got a ton of time left. I don't need to worry about that. But, as we all know, nothing is guaranteed. So it doesn't take a lot for those types of things to change. And then the best thing is to also have information that is transparent amongst family members and accessible so that in the event of a circumstance that people aren't scrambling to find out what the wishes are of the elder, if the elder is no longer able to recall or is not in a position to locate those documents. So, and then there's a website at the bottom. And I think that is it. So thank you to everyone. And I hit my 45 minutes. So if there are questions, I'm happy to field any. Otherwise, I think it's open to discussion. Is that right, Ann?
Yes. Let me run some magic here and get everybody back in the let's see, I'm gonna stop sharing, stop your sharing, and then let's get everybody back in. Let's see. So, you can go ahead and ask your questions. I'm gonna work on getting everybody back in the, why can't get you off spotlight there, mister. So let's see, let's do gallery view. There we go. So the floor is everyone's. You can unmute yourselves and ask your questions.
Hi, Costa.
Hey, Esther, how are you?
Good. I was wondering if you could address, our clients oftentimes spend a lot of time thinking about and putting together these really great plans, but maybe you could address sort of what your experience has been in doctors actually respecting and following those plans.
That's a great point. I mean, it can be very frustrating because we have situations where, depending on the hospital, depending on the doctor, depending on the age, depending on the diagnosis, we get different results. So, I've had situations with, Kaiser where I can get a CD really quickly if I need something for a client. And I can have doctors provide that information to allow for family members to get that information. And then I have other situations where I have to go through legal and it becomes troublesome. I've had situations with conservators who have documentation that the elder, stated their wishes, and then the hospital has its own protocols or the doctors have their own protocols. So there is definitely a unfortunate, square peg in a round hole dynamic that happens from time to time. So I think it's helpful, obviously in hindsight, 2020, if a planner can find out where the client's treating physicians network is or belongs to, or things like that, to help streamline things, because it's just not as easy sometimes as saying, okay, I'll just pick up the phone, talk to your doctor, or just give them this paper, this should do it. John Muir versus Kaiser versus Sutter Health, all those can be different.
Okay. Thank you. I have another question unless somebody else wants to go. Have you ever had a situation where you've had a pulse that is in conflict with an advanced healthcare directive? And in that situation, which one would prevail?
Yeah, we have, the facts of that case dealt with someone who had questionable capacity and a plan that was not necessarily in line with their current wishes. And the pulse was something that a court-appointed attorney felt was more sufficient in regards to honoring the wishes and having things done a certain way. So, it can be a very case-by-case situation in that regard. I've seen pulse that people who are over 100 years old, who are in end-of-life scenarios, have at their bedside with caregivers so that they know what's going on and so that people know that there's a DNR or there's not. And so it can be very helpful, even if you have a situation where there is an advanced healthcare directive, and even in situations where they don't necessarily align in some of those regards. Sometimes healthcare directives are left blank in regards to DNR or not, and then the person later says, I want that box marked. Well, now they can't do it. A pulse would be something that could be used.
Okay, thank you.
You bet.
Costa, I've got one for you. Terry Murphy here.
Hey, Terry, how are you?
How are you? The court appoints you as guardian ad litem for an individual that has no estate planning documents. And then someone, for example, county council comes in or the public guardian comes in and wants authority to execute a post order. How's your role differ if you're appointed as GAL versus attorney for the individual?
I love your questions because they have a lot of layers and are very thoughtful. So as court-appointed counsel, the duties that are owed, and depending on the philosophy of the attorney, can be as an advocate for the client, for the court-appointed, for the conservatee, versus a guardian ad litem where you're more independent. You're able to essentially take on a bit of the decision-making as an officer of the court and report to the court because that's why the court is appointing you. So in that regard, that's the dichotomy that I often see, is that a court-appointed attorney is there to advocate to the extent that the client has wishes and to let the court know what those are, whereas the guardian ad litem is essentially an arm of the court and can tell the court, this is my opinion, this is what I base it on, I believe this would be in my client's best interest.
Now, if a follow-up is, if the individual has no written expression of their wishes, if you're GAL, are you locked into Wendland, making a determination regarding best interests? Or do you feel that as counsel, you need to advocate for preservation of life if there's no expression of intent to the contrary by the patient or the individual?
Yeah, I mean, again, fantastic, great questions. Those are the tricky, tough ones that are very case by case. I mean, it is tough to just put an absolute on something like that. I mean, I see where you're going in regards to the difficult nature of making a decision in that situation, especially, you know, given the just gray area. But, you know, it's unfortunately going to depend on a lot of the facts and circumstances.
Well, thank you. That's why I tossed it your way.
Thanks, Terry. If you guys notice, I'm sweating now. I mean, he really asked some tough questions, so.
Anybody else? Come on. Test the man.
I think that means we're good, Ann. I think everybody's ready to get back to
Okay.
their day.
Okay, 1 second.